Yes.
Page 471. Lord, this is Anamika Mishra, a judgment of Lord, a bench of 3 of your Lordship's court, 3 learned judges, my Lord. Para 4 may be seen, my Lord. We heard the counsel for the parties and are of the view that when no defect was pointed out in regard to written examination and the sole objection was confined to exclusion of group of successful candidates in written examination from interview, there was no justification for cancelling written part of the recruitment examination. On the other hand, situation could have been appropriately met by setting aside recruitment and asking for a fresh interview of all eligible candidates on the basis of written examination and select those who on the basis of written and freshly held interview became eligible for selection. Now, my Lord, your Lordships therefore struck a balance. Now, this balance has been approved by Justice Chandrachud speaking for this court at page 299. Page 299, and Lordships may turn to para 35 first. Lord, this has discussed, Lord, very beautifully the balance between, Lord, the illegalities and, Lord, not doing damage to those who are innocent. Para 35 may first be seen at page 329. In deciding this batch of SLPs, we need not reinvent the wheel. Over the last 5 decades, several decisions of this court have dealt with fundamental issue when the process.
We are aware of the case law, Mr. We need not.
No, Lord, what I am trying to say is this. Just allow me a few lines.
You have also said so.
Yes.
If it's possible to segregate cases, and there is every possibility of segregating cases, that exercise must be done.
That's.
But if it is not possible to segregate cases, then the whole thing will blow up.
Yes, no.
I bow down, Lord. But what my respectful submission is this, that no effort has been made here.
We understood.
Court has been carried away. Lord, learned single judge who ordered CBI inquiry had no basis to order such an inquiry, and the division bench has simply been, Lord, overwhelmed by the CBI, Lord, investigation. Now, the criminal case is pending. Supposing, Lord, the criminal case fails tomorrow, Pankaj Bansal is unable to, Lord, support this. What happens? All of us.
There are 2 different standards of proof required. The issues are different. Civil liability and criminal liability.
No, not on liability, Lord. We are all.
Civil issues, that's not the question they're examining. They'll be examining on the basis of whether who is guilty, who's not guilty.
No, not that.
Even if the offense is supposed to be committed, who is guilty, who's not guilty. Here, it's not that. That's not the issue.
I agree, Lord. But my respectful submission
need not go on that aspect.
No. My respectful submission is that we are sought to be thrown out on the basis of that at this stage. That's my submission. Number Lord, one sentence the court says, to treat innocent and the wrongdoers equally by subjecting former to the consequences of cancellation of entire process would be contrary to Article 14 because unequals would then be treated equally. This is what your Lordship said, Lord. And paragraphs, Lord, 2 more paras, 47 and 56, Lord, I commend for your Lordship's acceptance. Paragraphs 35, 47, 56 and 64.
Okay.
Now, Lord, this, Lord, one more judgment. Lord, in the
need not go ahead.
No,
that judgment has been referred to.
Just take the citation pages. I'm not going to read, Lord. Inderpreet Gehlon, Lord, at page 357, para 41 and 119. And there again, your Lordship said that yes, there are some irregularities, but we are not going to send people home lock, stock, and barrel.
That's been read out.
So, my Lord, I respectfully submit that therefore, my Lord, these petitions deserve to be allowed.
Now, my Lord, I appear for 2 groups of people below. One is teaching staff for class 9 and 10, and one is group B, non-teaching. There are 4 groups below. C, D, 9 and 10, 11 and 12. Total, my Lord, of 4 groups who took the exam is 20 lakhs. There were 20 lakhs odd OMR sheets. My Lord, all the exams process was between 2016 and 17. I am not giving you the dates. In all cases, my Lord, under statutory rules, the waiting panel is for 1 year. The waiting panel, my lord, in all cases expired, my lord, in 2019. We are those, my lord, who were in the main panel, who were selected. We are not a part of the waiting panel. There are three allegations, my lord, essentially, in the writ petitions filed in the year 2021, which is 3 years or 2 years down the line after, my lord, our Pakka appointments. And I say, my lord, and I have seen, in none of the writ petitions, the way showed you one, in none of the writ petitions, my lord, is there a prayer that you strike down and remove those who have since been appointed in government service. The respondents, my lord, do not include those who have been appointed even under a representative capacity under Order 1 Rule 8. Those were the nature of prayers. Basically, prayer was, you give us an appointment in the year 2021. So there are three types of allegations, my lord, apart from this prayer business. One, that people, my lord, have been appointed from the waiting panel after the waiting panel. We don't represent those people. Second allegation of, my lord, rank jumping. Somebody is at number 10,000, he is brought in at 5,000. And the third allegation is this tampering of OMR sheets. Now, my lord, please note, the OMR sheets, my lord, which are physical, like an exam answer sheet, the rules require their destruction after 1 year. So all the 20 lakh sheets have since been destroyed. The OMR sheets, my lord, as sheets go, was never uploaded anywhere. What was uploaded, my lord, was only the result. Now, my lord, I want to tell you what the process was. Kindly note that. The commission, my lord, is authorized to conduct exams and appoint people. The commission outsources, my lord, to a company called NISA. It outsources the job of scanning the 20 lakh OMR physical sheets into an electronic form, like an electronic photocopy, my lord, if I may use the phrase. And then NISA, my lord, has to evaluate. And the evaluation is through a computer. It's not physical evaluation. That one answer is correct, one answer is wrong. It's an evaluation because it's 20 lakhs. Evaluate, my lord, the OMR sheets according to the key answers. Give, my lord, the final result thereof of the analysis to, my lord, the commission, and the commission, like a post office, will publish the result. This is how, my lord, it was given to NISA. What NISA did was, my lord, the job of scanning, the mechanical job, was, my lord, assigned, or you can say sublet, to a company called Data Scan, my lord. Data Scan. Data Scan Tech. I'm using Data Scan. So, my lord, what happened was the actual physical OMR sheets were electronically scanned, my lord, like a photocopy by, my lord, the agent called Data Scan Tech on computer. After scanning, my lord, they gave it to, my lord, NISA. NISA evaluated and gave the list of successful, etc., to the commission. So now what is most important, my lord, it is critical, apart from other things. The basic original hard disk, which will contain the first scanned copy, like a first photocopy, is the hard disk of the computer in which the scanning was done by data scan. That, Lord, is equal to the original OMR sheet. Because the starting point, Lord, is the original. Original has since been destroyed 5 years ago. This is the closest to the original because it was scanned, Lord, in the first instance. Kindly note that. So the original scanning is the scanning, Lord, of the original sheets. Now, please note, Lord, and I have gone through all the reports. The original hard disk of the computer which did the scanning is missing. It is not to be found. There is no reference to it. It is not there. So, my lord, any comparison with either Bansal or Niladri Das, to which I will come, that comparison is meaningless if you don't have either the original or the scanned original. So if you don't have a reference point, there is no gainsaying that some photocopy of somebody matches with somebody. That's very, very important. So the original hard disk, Millard, is not to be found. Number one. Number two, the Supreme Court was aware that, Millard, 3 hard disks have been found with Bansal in Noida. And found, Millard, your Lordship may note, in the year 2022, much after NISA was gone, much after the results, much after appointment. They were found with an employee called Bansal, or he's an ex-employee. 3 hard disks were found. Now, please note, Millard, something very important. The factum of finding these 3 hard disks with Bansal in 22 was known to the Supreme Court when the Supreme Court, Millard, ordered a remand. The date of the Supreme Court's remand is 9/11/23 to the division bench.
Which page?
Yeah, I'll give you the page note. Page is 734 of the convenience compilation, which I will now just show for a second, but just note this, Millard. Sorry. Volume 3, CC volume 3, page 734. Now, the Supreme Court was aware of the finding, Millard, with Bansal of the 3 hard disks. So the Supreme Court took pains, Millard, in that order. Kindly note, Millard, paras 6 to 9. The Supreme Court, in a nutshell, said that the issue of admissibility of what was procured from Bansal is extremely critical, and the division bench, Millard, will look into it. This is 6 to 9. I'll read it, Millard, in a second. Now, when the matter goes back, I'll just complete the sequence. When the matter goes back to the High Court, Millard, after the remand, the Additional Solicitor General produced, Millard, in a sealed cover, the 3 hard disks seized from Bansal, saying that they were sent to CFSL Hyderabad. Hyderabad returned it for whatever reason. Kindly just note that. They were sent to CFSL Hyderabad by CBI. They were returned by Hyderabad. They were produced in the High Court. And the Solicitor General said that since Hyderabad has been returned, we will send it to CFSL Kolkata. They were sent to CFSL Kolkata. But, Millard, that report has not come. And the division bench, Millard, has given judgment without awaiting that report, which according to them is crucial. According to me, it is not that important because the original, Millard, is still missing. Now, Millard, 6 to 9, your Lordship may note. At 734, kindly turn, Millard, to 737. And according to me, Millard, the division bench order suffers from a fatal flaw of not following the remand of this court on an issue which is critical. Kindly turn to Milord 737. Your Lordship have that. Civil appeal number so and so relates to termination of 842 of Group C, mainly based on the mismatch of data comparing the mirror image of OMR, which they claim to have recovered. This is recovery from Bansal. Authenticity of this material is yet to be established. SLP so and so involves termination of Group D, again on the basis of mismatch revealed from the content of the images, again from Bansal. SLP arises out of proceeding initiated by 9 and 10, mainly to preclude these OMR from being considered. So and so single judge posted the directed posting of OMR sheets, etc., etc. Matter came to now 7. We have heard submissions, etc. for so and so, so and so. We are of the view substantially varying all proceedings which generate the set of appeal ought to be conducted by High Court. We are apprised all writ petitions, etc. So my lord, it goes back. Then, my lord, your lordship will find, my lord, para 9. The question, or my lord, just one line above that. In none of the orders above para 9, impugned before us, there is no clear-cut finding that there is distortion. This is very, very important. No clear-cut finding of distortion. My lords, get that line just above para 9. So this has to be found, namely the distortion. That is the manipulation. For one of the three challenges, as I have said, my lord. Not rank jumping, not, my lord, outside the waiting period, but this. My lord, sorry, 2 lines above the para 9, very important. The argument of corrupting the original sheets is yet to be supported by cogent evidence. In none of the orders impugned, there is any clear-cut finding. The question of exercise of powers also arises out of discovery of electronically stored. Serious allegations of manipulation, record exchange of money, allegations have to be established through evidence. It is in our opinion, considering the importance of the matter, number of persons affected, etc., matter goes to the DP. Now, my lord, see what transpired in the High Court when the Solicitor General made that submission. The order, my lord, of the division bench, please note, is dated 5/2/24. And that order, my lord, is to be found in volume 3, page 958, in the same volume, at, my lord, 1014. I'll just read that one line. 1014, fourth line from top. 1014, fourth line. He submits that the ASG that the original electronic device, that is, Lord, seized from Bansal, was sent to CFSL, Hyderabad, who returned the same. The original appearance of CBI, in fact, brought to court. He submits that CBI intends to place these devices with CFSL Kolkata for necessary processing. The High Court returned the device to him that you send it there. This, my lord, went, my lord, to Calcutta, but has not seen the light of the day. So, my lord, the remand by the Supreme Court on something which is seriously contested, something which is the base of the matter, is sent, my lord, to CFSL on 5/2/24. It is recorded and judgment is given. And that, my lord, you'll also find 1016 bottom. 1016 bottom.
We are aware of all this.
Yes. So, my lord, this is how it is said. This is how, my lord, it has gone. Now something very, very important, my lord. So the whole focus was on the 3 hard disks, my lord, which were seized from Bansal. I submit, my lord, Bansal had no right to have them. God knows how they were with Bansal, in what capacity, my lord, they were there. Whether they were tampered at Bansal's end, we don't know. All this time has elapsed. And Bansal's certificate of 65B, my lord, according to me, is bunkum. But something very, very important now. In the latest, my lord, report by the CBI, it is, my lord, a 3rd supplementary charge sheet. Please note that and I'll read that. In the 3rd supplementary charge sheet, my lord, now new material comes. That is supposedly, my lord, a hard disk, my lord, from a man called Niladri Das. Niladri Das, my lord, is the current employer of Bansal. He
Yes.
Employee of Bansal or employer of Bansal, that's the connection. The name is Niladri Das. Now, Niladri Das, my lord, also has a hard disk. Apparently of the same exam. I don't know how, where. And this is, my lord, their investigation. Now, it's very important to note, this is investigation, my lord. This is not final proof. This is not evidence, it's investigation. But for whatever it is, have a look, my lord, at that report. This, my lord, report is, my lord, is called IA 4242 of 2025 in SLP 9637 called Gopinath Bhanja. That is not, my lord, in the
67.
is not in the convenience, my lord, because it has now come. It is, my lord, IA 4242 25 in SLP
4242.
4242 by 25 in SLP number 9637 by 24. The name of the case is Gopinath Bhanja.
Yes.
Now, my lord, in this your lordship will find. Anyway, my lord, it's a part what CBI has given. The CBI has not given to. It's a part of the charge sheet. One.
9637 is the IA number.
Now just see this, my lord. Your lord, if your lordship will have this, this is how it is filed.
This
It is SLP, my lord, 9637.
number is 4242.
IA 4242 by 25, my lord.
Okay.
It is a thick volume.
Why do you want to show us this? Why do you want to show us this?
To show you, my lord, that all is not ending with the sacrosanct, my lord, hard disk of Bansal. There is some Niladri Das whose hard disk now says only 152 are tempered as opposed to 4,000 tempered in the High Court, 952 tempered before the Supreme Court, now only 152. What is going on? Is what I want
How
to
can you say from the hard disk how many tempered? How can you say from that?
My lord, CBI is saying, I am reading from CBI. I want to show from CBI, not my statement, my lord. Just turn to 163 of this compilation. Yes, this is the one.
Can you give us a copy? We don't have a copy.
But I have to take it from CBI. CBI के पास है, मेरे पास थोड़ी है.
आइए कॉपी पे 2025
ये छोड़ो ना यार. Kindly, my lord, have a look at 163.
Yes.
The lordship will find. 1 minute, please. Kindly see at 163 bottom. Para 59.
Para 59. No, it's not there at 163.
163, my lord.
74.
My lord, on the top it is 163, handwritten page is 153.
What is the date of this supplementary charge sheet?
8 January.
On
24.
top it is
163.
My lord, the printed page right on the top is 163. A handwritten page encircled is 153.
Not this.
no. Next one.
My lord, if lordship may have, Mr. Courtmaster, kindly see this one.
Yes, now,
IA volume 1.
Yes, yes, yes.
Lord, para 59 at the bottom of the page.
Yes.
Conspiracy of Niladri Das and Naisa during investigation prior to recovery of disc from Bansal, so something before which has not surfaced till now. Niladri Das also submitted one hard disk providing data relating to so and so pertaining to teachers, that is 9 and 10. Scrutiny of the data of hard disk produced by Niladri reveals an OMR sheet, including OMR of 152, whose OMRs are found to be manipulated. In his statement, Bansal has stated he was asked by Niladri Das to prepare one hard disk for submission to CBI. So much for this, my lord Bansal. To submit one hard disk for Bansal, Niladri directed Bansal not to keep the sheets pertaining to those candidates whose OMRs were manipulated due to negligence of Bansal. OMRs of 150T could not be removed from the hard disk which was provided to CBI. This proves a conspiracy. Now look at this. Now Bansal said, according to Niladri Das, Bansal prepared his own hard disk to be given to CBI. So he's giving something to CBI. He's got something in his pocket, something Niladri Das has got. So, Milord, what is the proof of this investigation? What is the worth of this investigation? And therefore, the affidavit, Milord, of CBI, on which the High Court placed reliance, cannot be, Milord, looked at all. This is the state of evidence on which, Milord, thousands of people serving for the last 10 years are to be ousted.
Mr.
Now-
what is stated is something different.
Lordship is
What is stated over here is that Bansal had asked him to remove all this, but he says by...
That is the subsequent part. But see the third line.
But
In his
he could not
statement,
remove.
Bansal stated he was asked by Niladri to prepare one hard disk for CBI.
Correct.
What does that mean, my lord? That one chap is saying, I asked...
No, but he wanted to prepare a hard disk removing all those...
Correct. All I'm saying is this material on which you check out people? Why did the High Court not wait for CFSL Kolkata?
We take it overall material, not one particular evidence.
My lord, what is overall material is only Bansal. There is no other material. Only
Overall
Bansal.
material is OMR sheets have vanished.
Not vanished, Lord. They are destroyed after 1 year under the rules. We can't help it. Lord, rules say,
Now,
can
the
anybody
scanned copies are revealing so many other things.
original scan is not available. Original scan in the hard disk of
All the more reasons we have when there's so many
But
irregularities.
my lord, what can I do? They are not in my control. Nobody is alleging.
I know, we are not. Look, please. Question is not that. There are two questions. There are some people who have been found to have manipulated. Their results are manipulated.
I am respectfully submitting. This finding of manipulation is not conclusive. It cannot be based on conclusions of this nature.
Okay.
And then to do away with services of thousands of people with families after a lapse of below 5 years or 7 years, at the instance of a writ petitioner who took the exam, who lost in the exam, and then filed a writ after 5 years. Milord, there is a rule of estoppel. This court has created any number of judgments. You take an exam, you fail, you wait for 5 years, fellows are getting, Milord, jobs, and those jobs are now to be ousted. That, Milord, is my submission.
May I take 2 minutes?
I'll just take 10 minutes.
I just-
Also, I'm appearing in 3 of these cases, less than 10 minutes. Actually.
Mr. Symbol.
So, Shadan.
You want to come?
I'm appearing for the
So, Lord,
non-tainted category, Malat.
Well, I am also for non-tainted. I'll go
I
after.
appear for 3 petitions, in 3 petitions, my Lord, all untainted. The difference is that in one, they had been selected earlier in an earlier selection, and therefore they were already in service when this exam took place. However, they took this exam because they wanted a district closer to their home. So that is why, because some of them got districts closer to their home and through this selection, therefore they got selected. I am appearing, my Lord, in 34.11.
Give your judges, otherwise we won't be able to write it down like that.
34.11.
Put it on a piece of paper. We won't be able to.
Yes, my Lord.
There's
We
so
have
many
a
of you over here.
we have a piece of paper. I'll just give it to you. 34.11, 34.12.
What's your argument, Mr. Prashant?
Yes, my Lord. The argument is simple. That the High Court has quashed all the selections. In this case, even assuming that this Bansal's hard disk is a correct copy of what was there originally, that CBI itself has separated those whose marks were manipulated and those whose marks were not manipulated. If your Lordship sees, and it is on the basis of that very hard disk found with Bansal. If your Lordship sees the CBI's written submissions, which are in volume 6, I believe, they're in para 5, 6, page number 25 of volume 6. And in that, my lord, paras 5, they say about the recovery of this disk from Bansal. Then they say that the investigation of these hard disks in the aforesaid 4 cases of CBI has revealed that numerous candidates were declared successful and were placed in the panel wait list who had submitted blank OMR sheets. This is one. Marks of written examinations, typing test, personality test, etc. were manipulated for various candidates in order to declare such candidates as successful candidates. This is 2. Accused officials of WBCSSC together with the accused officials of NCPL manipulated marks of the candidates to whom undue favor was bestowed. This is the reason why. The marks awarded put together totals to 3481 or maybe a lot more. But in any case, these are the total instances of manipulation. These are the total instances of number of candidates who submitted blank OMR sheets. Then they say during course of the investigation, the 3 hard disks from Bansal certificate under the Evidence Act was obtained from him. It was also revealed during investigation that during his working tenure, Bansal used to officially deal with such hard disks which he had retained before leaving the company, etc. Then they say the investigation has revealed that appointment of ineligible candidates was done by collecting bribes through an organized racket of agents. That's again the motive, etc. These bribe amounts were shared between agents, officials, and minister. The lists of ineligible candidates were finalized in the residential office of Partha Banerjee, which was then handed over to the concerned officials of WBCSSC. The accused officials thereafter, in furtherance of the criminal conspiracy, manipulated the marks of the candidates to declare them eligible for recruitment. Further, the accused officials illegally appointed ineligible candidates against vacancies which were supposed to be used on the subsequent recruit. So some people were appointed in excess of the number of vacancies, etc. Further, in order to remove evidences and any wrongdoing and avoid detection, original OMRs and digital data were destroyed by the accused officials. Pausing here, my lord. Assuming that of course, the original was destroyed, etc. But the whole irregularities and the manipulation have been discovered on the basis of these seized hard disks which supposedly contain a correct copy from Bansal. Now, assuming that to be correct, if we assume that to be correct, that tells you whose marks were manipulated, whose marks were not manipulated. It tells you who had left blank OMR sheets, who had not left blank OMR sheets. It tells you who were appointed in excess of the vacancies, who were not appointed in excess of the vacancies. Now, Lord, we in all these 3 cases in which I am appearing, I am appearing for candidates against whom nothing wrong was found. No manipulation of marks, no blank OMR sheets, not appointed in excess of the vacancies, etc. So on what basis, my lord, do our selections get set aside? Because even assuming that this Bansal's hard disk is the gospel truth, even then, my lord, on that basis, it shows that we are totally untainted, we are totally blameless. So therefore, my lord, and that's what your lordships have held in so many judgments. In Kahlon, in Rakesh, PU, I have, my lord, prepared a short written note on these judgments.
Okay.
Just hand over this.
So that law is well settled.
Yes, yes.
That law is detailed.
Yes, yes. Your lordship has settled that law. So therefore, in this...
We have understood your argument that it's possible to segregate the ones who are tainted from those who are untainted. So why not apply that?
Yes. And the second argument is, this is the second argument. We were not given any notice by the High Court. Throughout, my lord, neither a public notice nor any other notice was issued.
Everybody was aware of the proceedings. If you're not aware, then there's something
wrong. But, my lord, we don't...
Yes,
we didn't think that
I want to say something, my lord, if you not permit me.
You can't cancel...
Lordship may permit me for 2 minutes.
And, my lord, some of us...
Ranjit Kumar, you had already argued, I thought.
No, I know, my lord. I argued, my lord, but I did not have... Your lordship don't have my SLP numbers. So I just want to, because I am in the same category what Mr. Prashant Bhushan has argued, that I was working, one of us has to retire this year in May.
Okay.
So if your lordship could kindly, if your lordship don't mind, either note my SLP numbers, my lord.
You gave it in writing.
Sorry, my lord.
Just give it in writing.
Lordships, I'll give it in writing, my lord. And I have prepared a small note of 2 pages, my lord, if I may be permitted. I'm sorry, I'm not there.
That we are not permitting. That we are not permitting, otherwise we'll take.
So, my lord, had we known that the entire selections are going to be cancelled, then we would have, some of us would have probably applied to the court.
So that's too late in the day.
No such intimation was given to anybody. And secondly, my lord,
Just-
some of us had
You
selected
already-
the earlier selection.
Your Lordship has heard this.
Great hardship. Great hardship.
May I, Mr. Sibbal is next. Mr. Sibbal is next. Let
I'm
Mr.
just going to
Sibbal
take
go
2
next.
minutes. Your Lordships have heard it, Malas. The issue is very simple. If you want to manipulate the OMR sheet, it has to be scanned first. The original sheet can't be manipulated. It has to be scanned. Whatever scanning was available, the CBI has detected where there's manipulation, where there is no manipulation. The CBI itself has found that, Malas. And the fate of 775 candidates is at stake. So if there's a blank sheet, Malas, the CBI has investigated. If it's rank jumping, the CBI has investigated. If beyond the expiry of the panel, people have appointed, CBI has investigated. Now, Malas, in the so-called Bansal scanned copy, Malas, there are names of people whose OMR sheets are not manipulated. That the CBI has found. If the CBI has found that, Malas, there's no occasion for the High Court to say that I'd set aside that appointment also. There's no evidence at all. You have to set aside an appointment on the basis of some assumption. And if the records are not available, the original OMR is not available, how do you assume that since others are manipulated, this also must have been manipulated? At least the investigating agency has not come to that conclusion. So therefore, my respectful submission is, also have heard all this time and again, Malas, that at this point in time, there is no method for finding out that those whose OMR sheets are not manipulated should also, their appointments should be set aside. That's just unacceptable in law, Malas. That's all that.
Because I'm just making one submission.
One by one now.
Plus, the submission is, plus that segregation is eminently possible in this case. I am for C and D group, totally untainted. No AMR, none of the others. No problem with us at all. I'm in that group, totally clean. As of today, there is not even an allegation against any of my clients which I'm representing. Plus, why is it possible? Firstly, plus the High Court gave an opportunity to, the OMRs were uploaded. The High Court gave an opportunity to us to examine them. Some of us examined it, we found it identical. Not a single person objected to it in the High Court. It's noted in para 289 of the impugned order. I'll just read it. The 3 hard disks seized by CBI had been produced in court. CBI had granted inspection of documents downloaded from such hard disks to persons seeking such inspection pursuant to orders of this bench. None of the persons taking inspections have contended that the OMR sheets are not theirs. So, Mullah, the opportunity was given, it was examined, we are confirming it was ours. So today, if anybody is saying it's not ours, it's an afterthought before the Supreme Court, number one. Plus, number two, there is hashtags have matched from Data Scantech and Mullah, what was found with Pankaj Bansal. The argument there is that the file name has, the extension has changed, it's .dat. That was the argument that was made. Plus, my respectful submission is hashtag will match if the content of the file is same. If you change the file name, no difficulty, hashtag will still be the same. If you change the extension, if you make a Word file, a doc file, a PDF file, it will still be the same. But even if you press a space bar in actual file, in the open file, then the hashtags change. So .dat is irrelevant, the hashtags do match. And I don't want to be crushed with the others because there is some irregularity on their part. Plus, finally, is it identifiable today or not? I have made a one-pager. Those numbers of individuals and names are before your lordships, against which there is allegation either by the commission or by the CBI. Those are very much there. So your lordships are in a position at a granular level to identify the individuals against knock us out. But please don't bury us with the others because plus there is not even an allegation today. Plus the chart of one page is there. It clearly, I've given the page numbers. Group C, Group D. I've given the page numbers. If your lordships will go to these page numbers, the list of candidates is there. So granular level data is available before your lordships today to do the segregation. Only to that extent, my lords, I respectfully submit the High Court judgment is wrong. I'm grateful.
My lords, I also represent untainted teachers, my lords. My lords, just continuing this line, my
One by
lords.
one.
Yes, my lords, continuing this line. I represent untainted teachers, my lords. So class 9, 10, 11, and 12. We are not outside the panel. There is no irregularity. We have been teaching for 6 years already, my lords. So that is the first thing, my lords. And I am in SLP Civil 9586. I will hand over, my lords, just a few numbers for my lord's consideration, just to make it convenient. Now, my lords, just 3 very brief points, because your lordships have been hearing this for many days running. One, my lords, the CBI's own submissions, which are before my lords, in fact, gives you the numbers of 3 categories of those who are tainted. One, and this is in the note, my lords. So your lordships don't have to be inconvenienced, my lords. This is in my note, page 4. Page 4, ma'am. It's a very brief note, my lords. It just extracts data from the CBI's own
It's
submission.
not going to be possible to take notes like this.
Very well, my lords. This is
Yeah,
also
quite-
filed, my lords.
We are noting down whatever is there,
Yes.
but other than that,
It's volume 6, my lords. It's also been filed. It's been filed by the CBI. This note is also filed. I just thought for my lord's
Yes.
convenience. And the point here is very simply this, my lords, volume 6. The CBI says, now please see, my lords, when it comes to assistant teachers, which is the candidates who are untainted, who I
which
represent.
paragraph are you referring to?
My lords, this is paragraph 8, my lords, page 4. Paragraph 8 in my note, page 4. This is taken from the CBI submissions. I have only reproduced it. Now, 3 lakh candidates take the exam for teachers, assistant teachers, my lords. 3 lakh candidates. 20 lakh is group C and D. 3 lakh is this. Now, please see the irregularities or the tainting. And I want to show my lords this numbers, because please see the minuscule minority, which is this number. Assistant teacher, my lords, have this. Appointments after expiry, 183. Classes 9 and 10. And classes 11 and 12, my lords, have this, 39. Candidates beyond the panel or waitlist, 110 and 18. Now, please see the total instances of manipulation. This is on 3 lakh candidates. Please see, my lords. Assistant teachers, this is line 2, 952, 9 and 10. And 11 and 12 is 907. And the ones who submit blank OMAs is 22 and 15. So in each category, my lords, this is 8% and 10% of the total number of candidates who take these exams. Now, your lordships in Vanshika, now, my lords, I've just extracted a case which is part of the compilation for my lord's convenience. The High Court refuses to accept your lordship's jurisprudence in Vanshika Yadav, my lords. And Vanshika Yadav, page 5, is extremely important because my lords took the trouble of making 2 points in Vanshika. That at the first level, my lords, has this para 10 of the note, my lords. This is the last page. And
Yes.
this is in volume 7 of a compilation of judgments which my lords have. I've just extracted.
Yes.
Your lordships do 2 things in Vanshika. One, you take the trouble of segregating the tainted from the untainted.
Yes.
And please note the tainted vis-a-vis the teachers is a minuscule minority. I've shown that from the CBI's numbers, my lords.
Yes.
Then your lordships make a second point in Vanshika Yadav, that even when the CBI investigation is underway, solely because there are irregularities of a nature, you cannot stop the process of segregation and terminate everyone. Your lordships have been confronted with cases similar to this because in this country, recruitment to government jobs, teaching positions, overwhelming numbers of candidates apply. Lakhs and lakhs apply for jobs in the police, jobs in teaching, jobs as engineers, and therefore there tends to be some manipulation across the board. But when the manipulation is of a nature of twofold, minuscule minority as well as the ability to segregate the tainted from the untainted, which our investigating agency is doing, then your lordships responded with Vanshika by saying the response has to be proportionate. That is the language your lordships use, that the response to a situation like this must be proportionate. The High Court, by refusing to segregate and by terminating en masse, even untainted like ourselves, who have not been heard, my lords. This is the other part of the story. We were never given notice. We were not heard. We have been teaching faithfully with due diligence over the last 6 years. There is not a blemish on how we've taken the exam or how we have cleared the exam. The High Court refuses to reflect on the jurisprudence laid down by my lords in Vanshika. And that is the element that I have compiled here on this page, my lords, for my lords' convenience. And my lords, very importantly, my lords, your lordships were troubled by the destruction of the OMRs. So I'd like to deal with that very briefly and head on. It's on the same page. That this is paragraph 12, my lords. And I'll end with this because this has troubled my lord, the Chief Justice. My lords, Rule 21, please see paragraph 12. I've extracted the rule. Rule 21 of the West Bengal Central School Service Commission, selection for appointment. And this is part of the volume of rules and statutes, which is part of my lordship's compilations. Service Commission, selection for appointment to the post of teachers for classes 9 and 10 and 11 and 12. These rules are specific per class. Very categorically say this, and I've extracted this. The written answer scripts, OMRs of examinations, shall be destroyed by the Commission after 1 year from the date of publication of the panel. It is now, at the time the High Court is seized, it is many years after the publication of the panel. In fact, I think it's 6 years after the publication of the panel. So there was not a concerted conspiracy. The rules and this rule in specific has been followed. For this, untainted candidates like myself, my lords, should not suffer. The investigation by the CBI, 3 supplementary charge sheets later, their submissions which they filed before my lords, all indicate that one, they have been able to segregate the tainted from the untainted. And if anything remains in terms of filing of the charge sheets, that is a process of enforcement of criminal justice, and that will happen. But for that, a disproportionate response is what the learned High Court does, my lords, which is en masse termination. That violates.
Next.
I beg to appear in item number 33.
May I?
Item number 33, I'll just take 2 minutes of your lordship's time. Lord, would your lordship turn to paragraph 240 of the impugned order? Lord, there is a table there at paragraph 240 of the impugned order.
So maintain the protocol.
Yes.
Lord, that paragraph gives the percentages of irregularity. It ranges from 8.5, goes up to 44.87. Lord, I am appearing for untainted candidates in Group C and Group D.
Yes.
Lord, the maximum is 44.87. Paragraph 242, the High Court says, Lord, there might be further possibility of further candidates, numbers increasing, but that has not happened. So the maximum your lordship would have is 44.87%. Lord, I am now citing Jeremy Bentham, Lord, the greatest good of the greatest number is the object of law. Lord, here, you're being invited to cull the entire number of sheep, cull them, just because there are a minority of wolves. Lord, when it doesn't exceed 50%, Lord, this culling cannot be done. Please don't throw the baby with the bathwater. Lord, if your Lordship then turns to paragraph 243 at the bottom of the page, last sentence. Bona fide candidates who had participated in the selection process deserved a lot better and far more humane treatment. Lord, this is what I would invite my lords to do. Untainted candidates deserve a far more humane treatment than mass culling. I'm obliged.
Milord, my case is a little unique, Milord. Lordship may kindly take up SLP number 16249. And I'll be, Milord, very, very brief. I'll just show 2 pages, Milord. 16249, Milord. 16249.
Yes, please.
Now, Milord, your Lordship can take it from me that I am one of the 33 candidates against whom no wrongdoing was established. That is, Milord, at page 460, read with 464 of my brief. I'm not troubling my lords, Milord. I am one of the candidates against whom no wrongdoing has been established so far. Number 1. Number 2, Milord, when the matter was before my lords, by the order of 9th of November 23, your lordships were pleased to remand back, Milord, 19 petitions to the Calcutta High Court. My matter, Milord, was not one of the 19. My matter was not, Milord, remanded back to the High Court. So I was not heard before your lordships, Milord, in this court. Number 3, Milord, the High Court on remand, Milord, directed notices to be issued. Notice was issued to me, Milord, in December 2023. Very next month, Milord, in January 24, Milord, I approached the Calcutta High Court and filed an impleadment. Now, Milord, kindly see the impugned judgment. I will just show 2 pages and I'm done, Milord. Page 157, Milord. Page 157. And para 124, Milord.
Yes.
In our understanding, all writ petitions relating to the recruitment process initiated in the year 2016 have not been directed to be heard by the division bench, but only those writ petitions relating to the categories as noted above in respect of the 2016 recruitment process and instituted in 21-22. Milord, this is very important. I'm so sorry, Milord. Page 157, para 124. I'm so sorry, Milord. 157 in my brief, Milord, para 124.
You're referring to the internal page.
Milord,
The running page.
Milord, it's a common one volume itself. I'm so sorry, Milord.
I see you're referring to the internal page. Here there are 2 pages. Paragraph number?
Maybe I'm looking at a different file. I'm looking at the first file. Oh, I'm looking at 33.
Let's read from my.
Yes.
Yes.
Lordship has it, Milord?
Yes.
I'll just read it again, Milord, quickly. Page 157, para 124.
Yes.
In our understanding, all writ petitions relating to the recruitment process initiated in the year 2016 have not been directed to be heard by the division bench, but only those writ petitions relating to the categories as noted above in respect of the 2016 recruitment process and instituted, Lordship may mark, instituted in 2021-22 and the appeals arising out of the orders passed in such writ petitions. Then, Milord, para 125. Consequently, we have the jurisdiction to hear and dispose of appeals arising out of the orders passed in the 4 categories of matters in writ petitions filed in 2021-22, contours of our jurisdiction to decide the writ petitions and appeals emanating out of orders passed in such writ petitions having been adverted to, we shall proceed to decide such matters which fall within our parameters. So what was heard, what was remanded by the Supreme Court was not, Milord, my matter. What was heard by the High Court, Milord, is not my matter because my writ petition was instituted in 2023 and not 21-22. And now your Lordship may kindly come to page 279. 279. 279, right in the beginning, Milord, and the first very line of the page. Lordship may kindly mark WPA 3846 of 2023. The para starts, my lord, from, my lord, page 275, conclusion, para, my lord, 364, 365.
Para 279.
My lord, page 269.
Para number.
This is, my lord, 365, 366, in fact, 366. Para 366 at 279, just Lordship may mark WPA 3846, which is my writ petition. WPA 3846 of 2023. And, my lord, at para 280, the last line, after, my lord, all the narrations of these WPAs are over.
Which paragraph are you referring to?
I'm so sorry, my lord, page 279. I'm so sorry.
First line.
Very first line, my
Very
lord,
first
of page 279.
Oh,
List of cases.
Para 366, page
Yes.
279, the first, my lord, the second, my lord, WPA 3846.
3846.
yes.
Your Lordship has it, my lord, 3846 of 2023, and at the next page, after the narration of all these listing, along with all connected applications are released from the list. So my matter, my lord, was specifically released from the list. Then, my lord, the next paragraph, 367. So far as the appeals are concerned, all appeals emanating out of orders passed by the learned single judge in writ petitions filed into 2021.
Just 1 minute.
I'm so sorry.
It's released of this report.
Huh?
It is not covered by this.
There you may not be covered by the judgment.
That's right. That is my only point. My lord, my matter was released. My matter was not before the Supreme Court.
Then why are you here?
Because I am affected, my lord, by the direction of page 272, I have been thrown out. When my matter is pending before the High Court. You know, this is really disturbing. Page 272, Roman 2. All appointments granted in the selection process involved being violative of 14 and 16 are declared null and void. My matter is still pending, my lord, before the High Court. I have not been heard.
Oh, your matter will be heard.
Yes, well, that clarification is all that
Yeah,
I'm asking.
1 minute, please. We have to read 1 and 2 together.
Yes.
Read 1.
Writ petitions appearing in the monthly list of March 24 of this bench, which are not filed and numbered in the years 21-22, are released from the list due to lack of jurisdiction determination. I do not fall, my lord. All I want is a clarification that, my lord, I cannot be, my lord, the effect of this order cannot, my lord, I can't be affected by this order.
Monthly list from this bench, which are not filed and numbered in the year, will be released from. No, this is also released.
This 23 and 20.
No, this will apply to the writ petitions which are disposed of. And not
Therefore, all that I'm saying is that I cannot be terminated on the basis of this order. That's all that I'm saying. That clarification is all that I'm wanting, my lord. Nothing more. I'm not entering into this dispute at all.
Who's the parent? State of West Bengal, please, on this point, just inform us. No, later on in your turn.
That's all, my lord.
The High Court website shows your matter is pending.
My lord, I'm so sorry.
The High Court website must be showing your matter is still pending.
It's still pending, yes. Yes. But that clarification, I cannot be dismissed, my lord, on the basis of this direction or not.
How can it be?
My lord, the state has to clarify.
State has to clarify, move an application for clarification to the court. We'll get that.
My lord,
Instead of running over here, you should have moved an application asking clarification with regard to paragraph number 2. With reference to the paragraph, it says such and such are released from this list.
My lord, I am told that they will not entertain any such applications. Why? All, my lord, result of this impugned judgment is all, my lord, appointed.
Okay, fine. Next case. Next
group appear for group.
May I mention, present, my lords, if I may, just one at a time, my lords. My lords, I am limiting myself.
I just want
my
to
lords,
mention 2 facts and get it.
I'll only take 2 minutes.
How can we permit this? We cannot have this.
I beg to appear in group
May
C groups.
No, please, no.
In SLP 10617.
You have also argued.
My lord, 1 point.
No, I have not argued, my lords. I have not present. I was not there, my lords. I am appearing for the first time before, my lord.
Okay, please.
So may I only take 5 minutes of my lord's time to submit
please.
on something which has not been addressed before this honorable court? I will not repeat anything, my lords. I'm limiting my submissions to the aspect of electronic evidence. I am in 34.63 for Group D,
What do you
tainted
say on
mallards.
electronic, what do you say on electronic evidence?
My lords, repeatedly, the issues with respect to the hard disks have been mentioned and about this provision of a 65B certificate or not. But the crux of the issue really goes beyond that to the provenance, and that decides every aspect in terms of the acceptance or otherwise of the evidence, my lords. And this is based on two judgments that have come from this honorable court and
We are not, look, please, let's be very clear.
I am not going
Last
to...
1 minute, please. We are not concerned over here with the evidence, sir.
Yes, ma'am.
Neither are we concerned with Anwar versus Bashir or Navjot Sandhu.
Yes. I am not going into Anwar versus Bashir or Arjun Pandit Rao to argue about the sustainability or otherwise of the electronic evidence, my lord. I am only limiting my submission to whether the so-called category of tainted can even be mentioned as such based on the evidence that the CBI is relying on today at this juncture. And I'm relying on the Mohammed Arif case of this honorable court, which talks about the first level that has to be crossed by the prosecution will have to be whether that is not prosecution, my lord, my apologies, for the state would be whether this is even sustainable for removing these persons from their appointments or not. The first, foremost, my lords, is that these are petitioners who have not been given inspection. They have been unilaterally categorized as tainted on the basis of the Pankaj Bansal seizures, my lords. If my lord sees, there is an assumption that one, that an OMR sheet which has been scanned cannot have errors. There is sufficient evidence to show, and this is something which has happened in terms of improvement in technology itself, my lords, which says that where OMR sheets earlier contained alphabets and there was misreading and errors in terms of the reading of those OMR sheets, now therefore it has been moved to multiple choice questions where the technology that is being used is merely to read a marking which is just filling in a round, my lords, instead of entering alphabets. Therefore, my first submission, my lords, is an assumption that an OMR sheet scanned is valid to decide whether a person is tainted or not in itself would be specious and would be unfounded, my lords. The second aspect that I'm submitting is, today, there is no evidence before my lords to categorize anybody as tainted. Because what is being relied on, let us assume, my lords, there are three sets of electronic records that have been recovered. One from SSC, where CBI has clearly said that the scanned documents are no longer available with SSC. All that they have are the ranks. Therefore, we are left with two other seizures, one from Pankaj Bansal, where supposedly a 65B certificate is given, and one from DataScan, whose very existence in the entire process is not substantiated. Assuming they have some copy, my lords, the provenance of that copy being original is not established. In fact, the so-called 65B certificate of Pankaj Bansal clearly shows that he only has external devices which are copies. And the 65B certificate at best reads like a seizure mahazar and not a 65B certificate. Therefore, I only want to draw my lord's attention to two aspects.
My lord, I am in item 34.5.
Only on this aspect, my lord. May I only draw my lord's attention to para 33 of Arjun Pandit Rao and 25, only to say that, one, what is required for a 65B is for the computer which originally had the data to be proven to be working properly and to have data input in the ordinary course of business.
Please. That's not correct. What it means 65B only requires is the person who's producing that data should say that this data from the computer as originally he had uploaded it.
Milord,
that Pankaj Bansal is in a position to
Milord,
say,
may I
because he's not an accused.
Milord, in fact, in page 25 of Arjun Pandit Rao, the court distinguishes between original and a copy, Milords.
Yeah, correct.
And also, Milords, point to
original and copy.
65B clear.
original and copy.
Only one aspect.
Original and copy also, there's a little, let me put it. Suppose you receive a CD.
Yes.
That's the original for you.
It
But
is
the
not.
CD may have been taken from another CD, or it may have been taken from X, Y, and Z. So when you give that,
Milords, I'm obliged.
1 minute, please. So that's a problem with electronic evidence. That's a problem because it can be transferred from one source to the other source
Yes.
to the third source. And if you look at the definition in the Information Technology Act, you'll come to know each are treated as original.
Milords, I'm obliged for this.
Lord,
Milords,
I am-
if I may just
Lord,
clarify
I
on
am
what
in
my Lord
item
said.
34.
Milords, if I may just take 1
I am
minute
in
to clarify
item
this, my
34,
Lords.
5.
What my Lord said
is-
leads to what I was submitting, my Lords, which is
Not required.
that the provenance in terms of where
strictly
CD
going
has
by-
been made,
we are
where an external hard disk
We are
is
not
copied from has to
strictly,
be set out.
1 minute, please. We are not strictly going by 65B. These are
No, no.
proceedings. Evidence.
But in which case,
Lord,
then
I beg to appear
the
for-
category shown as tainted cannot be treated as tainted as our submission, my Lords.
Lords, I beg to appear in
Lord,
this.
item 34.5, Saddam Hussein's petition, my Lord. I want 30 seconds, my Lord.
Okay, yes, yes, please.
I am 30 seconds, my Lord. This is
Just
Saddam
wait,
Hussein's
just wait,
petition.
please. For ones who are joining us through video conferencing, will have to wait after the physical, after we have heard the council who are present physically.
I'm appearing in SLP 10617 for the Group D candidates. I want to draw your attention first to para 340 of the judgment.
Yes.
May I read to your Lordship? Should be page 269 in the machine.
Yes.
In the facts of the present case, the writ petitioners had approached the writ court primarily to secure employment for themselves. Lordships have it, no?
Yes.
To secure employment for themselves. Please mark this. Orders had been passed in the writ petitions. An investigation had been carried out by the CBI, which disclosed a scam of an epic proportion. Order of the investigation through CBI had not been interfered by the Supreme Court. This is palpably wrong because in para 9 they say there is no cognitive evidence. Please go back for further investigation. CBI had registered 4 cases, filed charge sheets and supplementary charge sheets therein. State has taken into consideration the subsequent events and at the level of the cabinet decided to create supernumerary posts for persons who had been granted appointments illegally. Therefore, we are obligated to take into consideration the subsequent events, mold the reliefs that the parties are entitled to. We have to provide substantial justice between the parties, take cognizance of the subsequent event and grant relief. Now, if you have to look into this aspect, not all the candidates are tainted, but you've cancelled the entire selection process which has taken place. We were appointed in 2018, we continued in service, and our services were terminated in 2023 based on premises which the court says is yet to be established in Lordship's judgment of 2011. You remand it back. Say, please find out the causes. None of that has gone into. So therefore, if those of us who have been appointed, we have continued in service, I respectfully submit if there is no prayer against us, then the washing of our appointments is contrary to...
Okay, yes.
Lords, I appear in SLP civil number 10545.
Yes.
My case is little different, my lords. I appear for 2 of the assistant teachers in the 11th and 12th nutrition, my lords. There are altogether 74 posts which were available, my lords. My case is, my lords, that there is a mismatch of marks. But in any case, my lords, even if we go by the OMR sheets, I still qualify. I am above the cutoff. My lords, may kindly see my written submission I've made.
That may not work.
No, my lords, what I am, my lords, may I just say this one?
Sharma, you're being too optimistic.
I have no, my lords, I have not been put in the rank jump. I am not there. My name doesn't find mention in the rank jump. But the only thing is, my lords, of course, my lords.
Once you are in mismatch of marks, you are in.
But my lords, may I just say this, my lords? Even if we have to go by the OMR sheets, even if I have to go by the OMR sheets, then also I qualify. And my lords, the onus cannot be on me. It would have been a
The question is not of onus, it's preponderance of
But
probability.
my lords, it would have been a different. My lords, why would I indulge in
When
something?
there is mismatch of marks,
But
whole
lords,
thing collapses as well.
my only submission is, my lords, if I had to gain something.
We only don't know what has happened
No,
to
my
the
lords,
original.
I ask a question to myself, my lords. if I have to
Keep on
gain
asking,
something.
it will be good.
But even in the mismatch, if I qualify, why would I?
My lords, in item,
Then why
It was
the
just
mismatch?
one.
Why have it-
I was not even heard in the High Court.
my lords,
Integral to this.
my lords,
They have already argued that.
my lords, item 34.
In item 30.
My lords, item 34.25, item 34.25 and item 34.92. These, my lords, candidates of Group C and Group D, they are absolutely untainted. They have got, my lords, no misrepresentation, no fraud, no forgery, nothing. They are not actually connected in any way, my lords, with the OMR sheets, number one. Number two, my lords, the petitions were filed, my lords, in the High Court challenging the waiting panel. My lords, at page, my lords, in item 34.25, at page 364 is the prayer. The prayer is the waiting panel which has been issued in 2019 is not in accordance with the rules and therefore they should be set aside. It is not actually the 2017 panel, my lords, which have been published. There was no prayer at all. Actually, the 2017 panel should be quashed. All that they requested was that the 2019 panel should be abolished. Number two, 44, my lords, vacancies which were actually there, that should be filled from the reserve panel. It is not their case that none of the petitioners have ever committed any fraud or any irregularity insofar as their appointments are concerned. In the light of these facts, my lords, I submit, my lords, 3 points for my lords' consideration. One, we were not at all parties to the writ petition. We were not put to notice at all. No notice was issued by the High Court to us at any point of time. Suddenly, one fine morning, my lords, the entire appointments are quashed. Number one. Number two, my lords, in so far as our role is concerned, we have on our own merit, my lords, we have gone through and we have been selected from 2018 onwards, my lords, we have been working. Almost for 6 years we have worked now. There is no blemish found in our, my lords, work. Number two, my lords, the confirmation has also taken place. Now today, if my lords, you have to remove us after the probation period is over and you are wanting to terminate us without even simplest of a show cause notice to us, my lords, it's completely illegal. This is number two. Number third point, my lords, my respectful consideration is, my lords have held where, my lords, the untainted candidates, my lords, are sought to be, my lords, set aside. Their economic background, their systematic, my lords, evaluation, my lords, in their surveys, then, my lords, the livelihood which will be affected by virtue of this order, my lords, all will have to be taken into consideration. That's what my lords have laid down, my lords, in 2013-14 SEC, my lords, 494.
2013,
volume 14, SEC 494,
page,
paras 22 to 30, my lords.
paras 22 to 30. Okay.
Yes, paras 22 to 30. They have, my lords, gone into this issue. Untainted candidates cannot be clubbed with the tainted candidates for a number of factors. The court ought to take a sympathetic consideration insofar as untainted candidates are concerned for the simple reason that they have worked for a number of years without any blemish. Number two, their livelihood is being taken away. Their economic background has to be taken into consideration. They may become overaged by virtue of this, my lords, quashing. Today, my lords, the petitioners, my lords, or my lords, thrown out en masse according to this judgment, and we will not be in a position to compete in any of the examinations because we have become overage as of now. Despite the fact, my lords, we are in no way, my lords, connected with. My lords, these are the three simple submissions, my lords. I will, my lords, put a small note, my lords. With
May I make
Yes.
only 1 minute, my lord, I'll take. I won't take more than even 1 minute. I mean,
Tainted, untainted.
see, the only thing I am appearing in 34.5.50.
Tainted, untainted.
Lordship, may I have a minute?
But
I'm
untainted, can I, while you find out?
Just a minute. My lord, I am appearing for those persons who are in the wait listing.
Pardon?
Wait listed candidate. My lord.
Okay.
Now, my lord, we have not been in the job throughout from 9.
The panel list, the one in the panel after expiry of 1 year.
Yes. Now, no, the
What
panel
can be
was
done
there, and the
forward?
people have been taken, my lord, in the services, my lord, over us who were much below, my lord, who were.
Come on this side, no?
No, my lord, I'm a very petitioner. So, my lord, what I am saying in this matter, my lord, as now there are identification of all those people who have been irregularly appointed. There are the identification.
You should be appointed.
No, so no, what I want, I just want to convey, only one thing, that now,
You'll be over optimistic.
another 1 minute. What I am just saying, now at this faggot, after 8 years of being out and not getting job, now it's over, we have become overage, and now it has become difficult, and all those people who stand for the irregularities, they are in the service, they are going ahead with this job.
Okay.
So, the thing is,
okay, that's all.
My lords, may I just a very small this thing? It is to assist my lords also to identify tainted from untainted. It is there in CBI's own affidavit. Those who are the submissions filed herein. Would my lords please turn? Just can you allow us, please? My lords may see page number 27. My lords, in volume number 6 of written submissions filed by CBI. CBI gives the number of the cases, gives the total candidates, my lords.
We have got this list. We have got this list.
So, my lords, I'm saying I come in the category which was appointed in the 8th counselling round of the waiting list, but does not appear.
We have understood this argument, but there's a counter argument which you'll have to answer.
Please, my lords.
Look, the CBI will only file prosecution where they've got concrete evidence that this is done illegally.
Please,
correct?
My lords.
They identify the cases where they have been able to identify and say these are the cases where we have certain evidence.
Please.
Whereas what is examined by the High Court is much broader. It's much broader. It's much broader principles. Even if they are not, CBI is not able to find all the evidence against somebody, what is the consequence of this exam? Whether they will be able to find out whether there are more people who are tainted or untainted.
Yes. So may I answer that
and then
squarely?
they reach the conclusion it's impossible for us to verify.
Yes. So, my lords, may I answer that very squarely? CBI came with one list on which it believed was really tainted. I would take that. The West Bengal. Now, my lords, West
The
Bengal.
argument you can raise is, really speaking, is simple. Or not so simple, is that which you can argue is the High Court should have gone with the presumption that only people who are tainted are the ones tainted.
Please.
There's no other evidence available to show that others were untainted. That's all.
I am so grateful. So, my lords, I would only show you just one more
For
page.
that, you don't, I would quite so many arguments, but so many different.
No, my lords, then I'll just show you one more page and I will rest it there because that's the material on record which High Court could have looked at. Number one is the submission of the board, which is in line with what CBI is saying. But before the High Court, they had filed a document in which they had clearly said, so far as we are concerned, the appointments are only on the merit, except for the fact that the panel had lapsed. So they...
Panel has lapsed, so obviously there's some... Then there is a wrong thing which has been done.
My lords will find this at page 2624.
You are the ones who are in the lapse panel?
We are after, my lords, we were the waiting list. Counselings were held later on. If my lords go by the principle of a lapse panel.
Please, how do you justify your appointment? Answer
so, my lords,
let me forget about the tainted, untainted list.
So, my lords, let me answer that. So far as within that period of 1 year, there are only 2 sessions of counselling that took place. All the others were in waiting list. Subsequently, there were 10 sessions of counselling that took place.
That's irrelevant. That's irrelevant counselling.
My lords, may I just read this at page 2624?
Can panel be extended? Answer is no. The number of...
My lords, then I would really request my lords to look at the judgment. Then could the High Court would have taken off people who had no allegations of either OMR or to be under the rank jumpers against them, and were only for this. My lords, the only one paragraph in the impugned judgment.
That's the thing given by the High Court is when we have so many irregularities being committed on every aspect, it's impossible for us to find out who are the ones who are genuinely appointed, who are the ones who had backdoor entry, who are the ones who got their results manipulated, who are the ones who got their panel, etc.
My lords, then that is why I wanted my lords to see that page number 2624.
Okay, please.
Would my lords just have a look at that? For a minute, I'll read out. My lords, at the end of the list, it was mentioned as a note below, and this was filed before the High Court. And it says,
list of candidates, which is us, because we were the only panel before the High Court, and it is decided in one paragraph 282 of the judgment. It says, note below, list of candidates called for 8th phase counseling on 30th August 2020, that is class 9 and 10. All candidates are called strictly on the basis of merit, but after expiry of panel. This was the only and only allegation. And please see how High Court disposes it off. There's only one paragraph in the judgment, no other discussion, no reasons. Page number 225, give them the page in that. It's paragraph 282, if I may read it for your convenience. It reads thus. In the facts of the present case, SCC has placed on record several persons who have been granted appointments subsequent to expiry of the validity period of panel. Such appointments, therefore, have to be cancelled and are hereby directed to be do so. There is no other paragraph, there is not even a whisper so far as these candidates are concerned, against whom there is no allegation either on them. They are meritorious. There's not a case of rank jumping. Only and only thing is this. My lords, in one paragraph, without any rationale.
Okay.
My lords, the only last thing. We left jobs and we joined.
1 minute, please. How can you even justify panel has left its expired? How
so, my lords, the distinction of the argument
that we argued.
Yes. Now, this was argued before the High Court, and it was
understood, please.
Submitted that we are waitlisted, not a panel list. We said we are waitlisted. We were in the wait list. We were not in.
We have understood your argument, please.
My lords, only one last line. Only one last line. We left jobs. We were working, we were employed elsewhere.
If we accept that argument, it may have consequences.
My lord,
Lordship, may I just take 1 minute?
My lord, the fact that the hash value is not taken in 2016 is crucial to the matter. Allow me 1 minute to explain. My lord, the hash value, as has been explained, my lord, is like a digital photograph of a file. You can only use the hash value if the hash value was originally taken.
Then we have the original value.
But that was not done. Admittedly,
cannot be done because
it would have been done at that point. But it
cannot. But even if the hash value original time is not attainable, it can be verified by the experts whether there were any changes made in the file after it was original.
I'm grateful, my lord. For that, the only way is for a forensic lab to look into it. And for which, as Mr. Rodgi pointed out, the CFSL report is awaited. There are only these two ways of conclusive. There's been interpolation. But both have not been done in this.
I thought you had already argued.
So this is a different SLP plot. And I'll say something, not what I've said earlier. Lord, this is an exam which took place in 16. Original result 17. Apparently between 17 and 18, the manipulation took place and some people's marks were added. That's the allegation. Either rank jumping or, Lord, their marks were added in the OMR sheet. Now, how do you discover this adding of marks? You discover this adding of marks because you assume that what is with Pankaj Bansal or with data scan is the original, which is untainted, which is the original result. So that is taken as the original result. And what is with the West Bengal board is the manipulated one. And when you say that in this original result, these marks which are there in the West Bengal Commission website, 400, whatever number, 3,000 or whatever numbers are different from what was there at Pankaj Bansal's plot. And Pankaj Bansal and data scan is matching. So they say Pankaj Bansal and data scan had the original result. So up to the result and up to the declaration of the result which came, Lord, to data scan or to Lord Bansal, there was no manipulation. The manipulation happened from data scan to the West Bengal Commission where, Lord, these marks changed. So how do you say that 3,000 or whatever number is tainted, or how do you say that these numbers have been manipulated? Because you say they are more than the marks that were obtaining in the hard disk obtained from Bansal. Now, if hard disk of Bansal is considered to be the original hard disk, for the purpose of this, I'm not on the technicalities of evidence, etc. I'm saying if you're assuming that, because your lordships are not looking at a probabilities case, if you're looking that to be not the original, and if the only basis for saying that there are some tainted is on the basis of taking that to be original, then, Lord, the effect of the High Court order can't go beyond the numbers in the West Bengal Commission, Lord, website, which are, Lord, higher than what is there in the Pankaj Bansal's, Lord, hard disk.
Because otherwise, Lord, if this is not to be, if this goes, this hard disk of Pankaj Bansal goes, Lord, then there's nothing in the exam because we are all working for so many years. Lord, I'm the untainted. We are all working for so many years, nothing against us. We have 5-6 years now. And Lord, we have all become now overage. We have all, Lord, left jobs that come. So as far as our appointment is concerned, is completely flawless. Even if we go by everything that is, Lord, alleged on the basis of, Lord, the investigation that has been done by the CBI, because we are part of the in the comparative hard disk of Bansal and the commission, there is no change in our marks. And the original, if that is to be considered as original, Lord, then our appointment has to be.
If I may please your lordship, have 1 minute of your precious time.
There is one judgment, Lord, of 2021.
I'm representing about 1,000 odd people.
Lord, there is one judgment of 2021 where your lordships have dealt with in what cases you will take out tainted and in what cases. Just kindly have a note of that judgment, Lord, in some paragraphs.
Lordship, may I just take 1 minute of your precious time?
2021 volume 4 SCC 637.
Okay. Paragraph
2021 4 SCC
paragraph
3. Paragraph will be, Lord, 36, 41, 43, 48, 67, 68. So your lordships have dealt with in what cases where the whole thing that can't be deciphered as to who are all involved in, Lord, the mass copying or Lord, irregularity. Then only the whole thing has to go. Otherwise, in every case, this
may I, with deeply obliged lordship, what has happened? I represent about 1,000 odd people. There are seniors who are leading us in the individual capacities in those SLPs. Then 9, 10, 11, 12, Group C, Group D. I fall in the so-called allegedly mismatch category. There's one SLP that is 31169 diary number 34.104. Lordship, the reason I'm saying this is I filed an RTI application because my name was not called out in the first list. They gave me my OMR sheet and that remains untainted. That remains as of today. But by the High Court's order, that is on 7/7/2023, because I'm in 11th and 12th, 907 names were supposed to be published and we were supposed to be terminated. Now, this falls within the so-called mismatch, but there is no mismatch as far as the OMR sheets are concerned because the OMR sheets were available in 2018. 5/5/2018, Lordship, my OMR sheet is on record. This is, I'll tell you the page numbers. I'll not take your Lordship's precious time. This is diary number 31169 of 2024. The SLP is listed at item 34.104. The OMR sheets are available in annexure number P5, pages 309 and 3010. They had given me twice in 2018 and 2019, and they gave me my answer key. And I am much above the cutoff mark. What I'm trying to impress upon Lordship, even in the mismatch category, it has been given too wide a brush. I have not admitted there has been, in fact, in all the cases, there have been no.
You are in mismatch category.
Lordship?
You are in mismatch category.
I'm in the mismatch category.
Then how do you get out of it?
Lordship, because my question is, if I have to look into the Pankaj Bansal database where they say the OMRs were manipulated, the OMR was with me, the answer sheet, my answer string, my marks are there in visible capacity. They are printed and they are part of my SLP paper book because I was given those in 2018 and given in 2019 along with the answer key.
Does it tally with the board's marks?
This tallies with the
board's marks.
No, it doesn't tally with
the board marks. My OMR sheet marks did not vary because I have my OMR sheet. That is a mirror image. The entire question, Lordship, the
information is given to the board.
Yes, it tallies with the board's result. I was given by the
commission. That in fact destroys the whole case then. Then it's a case wherein if you have the OMR sheet, photocopy of the OMR sheet was given to you, and that OMR sheet is not matching with the OMR sheet available with Pankaj Bansal,
that is not the case.
Then that means all my sheets have been also replaced.
No, Lordship, that is my case. The OMR sheet, there is no mismatch.
That means OMR sheets have been replaced because there cannot be two OMR sheets.
Lordship, the original destroyed, but this is before the destruction. In 2018, I get it.
Mismatch between the OMR sheets. Has to be.
That is exactly why I am suspicious of the entire batch.
Yes, he accepts there is a mismatch between OMR sheet with Pankaj Bansal and the OMR sheet given to him. That means the whole thing is then gone.
No, Lordship,
You're supporting
with
them.
all humility. The is if I were to admit to this position, Lordship, then I need to see.
Undergone changes.
With all humility, Lordship, if I have to admit to that position.
OMR sheet has your name, it is your signatures, it has your roll number.
Yes, Lordship. Your Lordship may kindly have a look at it.
Thank you for supporting them. Please.
Your Lordship.
No, Lordship, I have
just one minute. My Lord, I have.
No argument, Mr. Patwalia.
My Lord, yes, I just want to point out one thing. I have filed an additional document. I have filed a supplementary charge sheet dated 8th January 2024. I want to read only one paragraph from that supplementary charge sheet. The High Court takes the CBI affidavit of 5th February 24 as the gospel truth and says, it says X tainted in one category, Y tainted in the second category. What this 8th January 24 charge sheet shows us is that there was another hard disk recovered from Niladri Das. And when that hard disk is compared, there are only 152 mismatches.
Oh, yeah, that's been argued.
Your Lordship may permit me. I am
Before
in the
they
corner.
begin, one very, very limited point that my lords had asked them to file. My lords had said, let them, since the High Court has swept aside, my lords, the Evidence Act, they have swept aside the Secondary Board of
Why swept aside? It's never applicable to petitions.
But my lords, those arguments, they have said these are not relevant. This is not relevant. The 2016 rules are not relevant. None of it is relevant. But my lords had told the CBI that you must file an affidavit which contains the metadata with regard to the comparison of the hash values of Data Scantech and Pankaj Bansal. My lords, that affidavit has not been filed. My lords have directed them. And my lords, that affidavit will show that it was not on the date. But my lords, let's file the affidavit.
Okay, we're closing now from this.
Yes,
my lords, let them file the affidavit.
Statement, my Lord.
Allow me to read one.
Your Lordship may,
to argue.
That's all.
Your Lordship may note down only one page, my Lord.
Allow me to.
Your Lordship may note down one page, my Lord. In SLP 1611.
I've been trying to argue.
Okay, please.
My Lord.
It is para 289 from the impugned order. What it says is this. It is in support of segregation. The 3 hard disks seized by CBI had been produced in the court. CBI had granted inspection of documents downloaded from such hard disks to persons seeking such inspections pursuant to the orders of this bench. None of the persons taking inspections have contended that the OMR sheets are not theirs. Please note this, my lords, now. The OMR sheets bear unique barcode and have several features which distinguish one OMR sheet from the other, such as the signature of the candidates, as also the invigilator and other aspects. Now, read with this, my lords, I rely only upon CBI's para 12, CBI's written submissions, which says this, that if required, the CBI will provide the details of the individual candidates who received appointments illegally, as mentioned in the above mentioned tables. I'll just end it here. Lot has been said here by one statement. I had nothing to offer but my merit then. I have nothing to offer but my merit now. In future,
Your Lordship,
anything.
One person more. Just one person more. We close.
One page, my Lord, only in 16111 SLP, my Lord. Volume 2, my Lord. Page 6761.
What do you want to say?
My Lord, these are 47 petitions.
Tainted, untainted.
All untainted, nowhere in any of the lists. The chart that I have placed, my Lord, in volume 2, this is...
What do you want to argue?
My Lord, they have from 2014, 16, 10, 2006, they have been working somewhere else. There also their appointment was clean. For their future advancement, my Lord, they preferred to join this position, my Lord. Here also they are untainted completely. And at this stage, where against me there is nothing, I am being told that you are out. So that's why, my Lord.
Only one submission.
My Lord.
103.
I will only hand
My lord, just one
There is
submission.
one unique one of a single candidate where, my lord, under the orders of the court, my lord, when I found somebody jumping over me, I approached the learned single judge.
My lord, my item number is 1.90, so 34.
Mr. Dollar, you will be in the same position.
And
Okay, on this side we are closing. Now we'll keep it for you.
Just a minute by clock, minutes.
Okay, just 1 minute. There is a council who wanted to address us through video conferencing. Let him come. Let him say.
1 minute, Milord. Milord, I am in item 34.5.
Yes.
This is Saddam Hussein's petition, Milord. I am group of about 58 people, and we are untainted, Milord. Milord, your lordship has been inundated with the factual and technical metrics of the matter so much that your lordship is fully equipped now to do justice to everybody there, because it's a right to life, right to live, and right to employment. And we are untainted group of 58
Okay,
people.
fine.
Just
1 minute now.
There is only one. Lord, under the orders of the learned seat.
Oh, it does make a difference.
The division.
No, that issue was slightly different. Less.
Your lordships may just hear me for 20 seconds, my lord. My case is slightly different, my lord. Lord, I am in a very peculiar position. What the High Court does, my lord, I am untainted. I have worked. But during the proceeding before the learned single judge, I was asked to deposit entire 4 months, 4 years salary, my lord, which I have done. And that was supposed to be given to my lord's one Babita Sarkar. Subsequent order says, my lord, and she is thrown out, and my lord's appointment is given to a third person. But I am saying my money, my lord, which I have rightfully earned for 4 years, I am untainted. How can my application, my lord, that money may be secure till your lordship decide ultimately, my lord, who gets what?
Kamad, we are not going to help you in that case.
My lord, my hard-earned money, my lord, of 15 lakhs odd, which I have earned, High Court, my lord, says that you deposit. I have deposited the money.
27th of January 2025.
My lord, I had a small.
No, there is one.
My lord, I am not covered by that, my lord. I am not covered by that. Kindly have my IA, my lords. 256034.
My lord, there is.
Tomorrow, first matter, is it possible?
My lords, I'm.
My lord, there is. My lord, for the state. Not 1 minute.
10 seconds, my lord. My lord, tomorrow, can it be possible?
That was asked in the last occasion to hand over.
My lords, for the state of UP, state of West Bengal, your lordship said that point number 2 will be argued later, my lord, that relating to the government order, my lord. Direction number 8.
But is it tomorrow for me? No, tomorrow morning, I believe.
No, not 20, tomorrow.
Not tomorrow.
No, because we are sitting in 3 judges bench.
Okay, 27.
Regarding what?
27th, our
You give a copy to the other side, we'll take it up on the next one.
But 27th, Lord.
I'll not keep it and give another.
My lord, I had a small request, not at all on the merits. My lord,
Might an earlier date be possible, either the 17th or the 20th?
20th is going to be slightly difficult.
Please.
21st, 27th, that's it.
27th at 2 p.m. Lord.
2 p.m.
2 p.m.
Fair enough.
Very true.
my lord, could I make a small request before my lords close the petitioner's side?
Yes, please.
This is a matter, item 34.17. There was one of the respondents who couldn't afford representation. So he filed a legal aid application. I've come on record for him. I filed a transposition application. My only request is he may be transposed, he may sync and my colleague will hand up. Yes.
Just give the details that application for transposition is allowed.
Any witness candidates have filed this kind of application to be transposed as petitioners who have got appointment. We need to see the application. Lordship may not allow today. Let
Okay, let it wait. Let it.
My lords.
My lords.